Hello, everyone. Welcome. It is Friday, September 10th. I hope you guys are having a really good day. I was waiting all day for the prosecutors to file their responses, which is why it took me so long to get things done. And then, you guys, I did a video where I was like ready to edit it. It was going to be about Kate Gosselin. And as I finished recording that video, I double checked on the file because I knew they were filing today. Today was the deadline. And then everything was there. Legitimately, all the responses were there. And it's a lot. There is so much to unpack here. But one of the things that I want to start with is one of the more damning pieces of evidence. And interestingly, the Duggars, or Josh Duggars, he was offered a plea deal in March. So ahead of the grand jury indictment, the government actually let Josh and his lawyers know that they had all of this evidence. They laid out the entire case. They offered him a very nice plea deal, and he declined it. And then they went to the grand jury. They got the indictment, and here we are today. So on March 19th, this was also around the same time that random episode came out of the Duggars. And remember, they looked all like startled and weirded out. Well, probably weirded out because all of this was going on in the background. And there's actually the evidence. Now, here's the problem with Josh is that they made a lot of claims in their suppressions and in their throwing out the cases that it kind of forced the hand of the government to share some details. And those details are damning, you guys. One of the bigger things that we talked about specifically was around the photographs of his hands. So we had talked about how Josh's attorneys claimed that their photos were taken in custody that were without a search warrant. And Josh was intimidated and scared. And, y'all, we were like, why are they so obsessed with these photos, right? And I just want to show you the pictures because the response by the government doesn't actually have the hand, but I can show you why they are so concerned about this specific picture. So their concern comes down to something that's on his hand and a visible something that's on his hand. And that visible something is a scar, and the scar was clearly visible in what they actually found on confiscated things they found on his phone. So I want to show you the photo of why they were so interested in these photos, and then we can talk about what the government responded. So here are the photos of what the government claims is visible, okay? So I'm going to just get you here so you can see this. I'll make this red. Can you see where a scar might be on his hand? Right there. Do you see the scar? So this scar on his hand, which is clearly visible, apparently, in content on what they found on his phone. No, the scar is on his hand. So do you see where I put the circle there? All right. Okay, no P word in the chat. Let's not use... If we're going to call people the P word, use the P word. Don't type out the whole name. I don't have any moderators here, so please be mindful of using words like that, okay? Okay, yep, it looks like it's a dark burn mark. All right, so let's actually talk about what the documents say by the government. So it says that on April 28th of 2021, they were sitting in the Western District, Arkansas, and they returned a 2-count indictment. And while the defendant was being processed, he was taken into custody, and then a special agent with the Department of Homeland Security asked the defendant if he could photograph the defendant's hands. The defendant consented to having the photographs taken, and at no time during the process did the special agent or any other officers involved in the processing of the defendant raise a voice at him, intimidate him, or physically threaten him. So they were processing him, meaning he was being booked. They were doing likely his booking photos, and they also were, probably taking his jewelry from him, that kind of stuff. And they say the photographs document a scar on the defendant's hand, which is plainly visible. Law enforcement observed the same scar in images from the defendant's electronic devices seized pursuant to a search warrant in this case. So I don't know if the images were photographs of the desk. It doesn't say if this is, you know how they were saying that they knew that he was sitting at the desk? I'm guessing that perhaps, oh, my husband's here, perfect. I'm guessing perhaps that they actually had photographs of the hands. So let me actually show you the documents here so you can see them. He is toast, yes. So it says that they're claiming that it constituted a violation of the Fifth Amendment for unspecified reasons, and law enforcement's photographing of the hand constituted a Sixth Amendment violation, right to counsel, for reasons that follow. The defendant is incorrect on all counts. They say that they didn't have a warrant as well. And they say a Fourth Amendment search occurs when the government violates a subjective expectation of privacy that society recognizes as reasonable. In contrast, whatever a person knowingly exposes to the public is not the subject of Fourth Amendment protection. So to the extent of search does implicate an individual's Fourth Amendment rights, such that a warrant is required. A warrantless search is still valid if conducted pursuant to the knowing and voluntary consent of the person subject to the search. So they say that Josh actually gave them consent to take these photos. So they say that the photograph of the defendant's hands did not constitute an unreasonable or warrantless search of the defendant. As made clear, the photographs included in the defendant's motion, his hands were in plain view and clearly visible. This is not a case in which law enforcement, for example, ordered the defendant to remove an article of clothing so that the officers could view and photograph otherwise covered parts of the body. Instead, this is a case in which law enforcement simply observed a documented physical characteristic of the defendant that is constantly exposed to the public. So if you have a scar on your hand right here, everyone can see it. And they say that protections of the physical characteristics of a person's voice, which are constantly exposed to the public, similar to a man's facial characteristics, handwriting, finding that the defendant has no reasonable expectation of privacy in the parts of the body that are exposed to the public on a day-to-day basis. The photograph of the defendant's hand was therefore not a search, and the case relied upon by the defendant does not compel a different conclusion. They say that neither the district court nor the circuit court has presented with the question of whether a search warrant was needed to photograph an individual's hands, and neither court made any specific findings to that effect. And they simply addressed whether the officers who obtained a warrant based on the particular circumstances of the investigation. So they say that even if it constituted a search, they still say that suppression is not warranted because he consented to the photographs being taken. So the defendant also consented to having these photographs, that he didn't not even have to manipulate or remove any article of clothing to accommodate the request. There is no allegation, let alone actual evidence, that law enforcement forced or coerced the defendant to do anything. So they also claim that his Fifth Amendment violations, there was no violations as well. The defendant provides no additional elaboration that there's a violation, although he may be arguing that the photograph constitute testimonial evidence taken in violation of the Fifth Amendment, self-incrimination. Such an argument would be confusing in light of the defendant's simultaneous claim that these photographs have no evidentiary value. So remember that in their motion to suppress, Josh's attorneys flat out said, we're not asking for these photographs to be dismissed or suppressed because we said there's no evidentiary value. And so he can't say that it was self-incriminating and then also say, they're arguing that you also can't say that there's no evidentiary value here, but then they also can't say, well, Josh, I self-incriminated myself by having these photographs. See what they did there? And they also say that the Sixth Amendment rights were not violated, and your Sixth Amendment right is your right to an attorney. One of the most important rights people in custody have, defendants have, suspects have. So he says that because they were in violation of his Sixth Amendment rights, once again, he provides little by way of the argument or legal precedent in support of this request. But he appears to be suggesting that these must be suppressed because they were taken after his arrest without counsel present. And once again, he is mistaken. As the Fifth Circuit has explained in rejecting petitioner's claim that his right to counsel was violated when he was photographed after his arrest, and that the photograph was used in identifying him in a lineup, and taking of a photograph did not violate their Sixth Amendment right to counsel. This is because the right to counsel only attaches to the critical stages of criminal proceedings, and the taking of photograph is not a critical stage of proceedings. So they said that finding no Sixth Amendment violations where agents took photographs of the defendant in jail, and noting that complaints about the lighting angle and relevance of such angles are misplaced, this should be denied in its entirety. So my suspicion, now they didn't say specifically like what images these photographs were found on, but they were very clear that they had images of his desk. And if you noticed, his hands almost looked like they were like on a computer, the way that the hand was not manipulated. But let me show you again. It almost looks like he has his hands like he's about to type on a computer. So what I think is that when he took the photographs, I think, and this is just my opinion, that it's because he was typing. So if you look how his hands are almost like how you would type, with your fingers spread out. And he's got his hands on like that spot like that, almost like his hands would be sitting on a desktop with his hands looking at and typing. So, and then obviously with it being public view, they say that this is a ridiculous request with no value. So this aspect I thought was interesting. Now, some of you thought it was because it's how they identify individuals in photographs. I think this has more to do with the photographs that were taken at his desk, because they had actually, his phone had taken pictures of the desk, and that was specifically laid out by the Gerald Faulkner at the bond hearing, that there was multiple photos of like the desk. And it might have been by accident. All right. So the next thing I want to talk to you about is that there's a lot to go over here. There were so many documents. I mean, so many. But the next thing I want to provide you is some information about what was leading up to the indictment. So I think in the 45, is this one? So they want all the evidence thrown out because of a motion to, it's about the warrant. And they were relying on they were saying there was false statements by one of the law enforcement agents. And then they also had presented with information that he didn't fully download content. But as a marked exhibit in their argument about this, I just want to tell you that there was conversations with his attorneys on March 19th. Josh and his attorneys actually all went to speak with the government. So on March 12th, Carly Marshall, the U.S. state attorney, sent Travis Story an email, and he says that it was a proposed document including information, calendar, plea agreement, and waiver of indictment. Let us know if you have any questions. We're uploading a couple of additional documents, including the picture referenced in the plea agreement. The plea agreement contains a statement of facts, which should be good summary reference when you're reviewing the discovery material. They say significantly, Duggar's cellular phone, including text messages he sent and pictures he took, places him at the car lot on the dates and times that the CP and images were downloaded and distributed. And there are several reports that set out the forensic evidence that establishes physical whereabouts, particularly ROI 12 and whatever. And so they basically gave all of the evidence to them ahead of time. I think they felt like they placed him there. It was him that did these things. And they wanted to give him an opportunity to just not waste the government's time with an indictment, not waste the government's time and resources with a trial, because they felt like it was pretty like slam dunk. But while they were going through this, Travis Story then decided to bring in Justin Gelfand, and they wanted to go into the office and have a talk, okay? So I'll show you what that all came down to. But again, it proves that there's no way that these people couldn't have known, because Travis Story was on here. Greg from the Story Law firm was also on here. And Justin was on there. And obviously, it says William Clayman and Carly Marshall, and then Dustin Roberts were all included in this. So here is what they, oh my goodness. That's not right. Hold on a second. There we go. So it says to recap the meeting, the proposed recipient of CP plea offer, the government provided defense counsel with an oral review of the discovery material that has been provided. And the government displayed the Marissa images and the video of the CP downloaded by law enforcement to defense counsel. And the government offered a review of all the CP images discovered during the forensic process. They declined to look at them. And they said during the meeting, defense counsel inquired about the law enforcement agency that did the initial downloads, and the attorney of the government stated it was Little Rock Police Department. There was also an inquiry about the defense about the procedure the case will follow if there's not a plea to an information. And the government indicated that it would follow the normal course of any CP case. Defendant would hit all the enhancements. And the defense likewise inquired about applicable sentencing guidelines, and the government stated that he would hit all enhancements, which would result in them recommending a 10-year sentence. So, however, there was no oral agreement as to sentence or promises regarding the accuracy of the guidelines provided. So they showed them at that meeting everything that they had that they downloaded. So one of the things that they argued in this whole thing was that they didn't have the images, and they didn't have there's no way that Amber Calmer had these images because she didn't get all the bits. And because of that, there's no way she could have had this. But they all sat down together and they showed them everything, and they declined to look at some of them. And during that meeting, they specifically told them what they had, and they told him that he would likely get 10 years if he took the plea agreement. So a 10-year sentence here tells me that generally with a plea agreement, they take off it's like, I don't even know what, 40%. So I don't know what, 60% plus 6. So they're probably looking at him, if he was to do this, he would be getting like a 16 to 20 year sentence. So you can be offered around 10 years. They didn't nail that down, but they just said that this is around what he would have gotten. And he declined that. So it's interesting because they want to argue that they withheld evidence, or they said let me see here. Their argument was that Gerald Faulkner said that a complete file was downloaded. And then he says that that's not true. So that was what his defense said. So they said, well, Amber didn't actually download the full files. And so they're lying that all of those files were actually downloaded. And they're lying because there's no way that she could have done that, right? Well, they have an affidavit on here from Amber, which I can't find. But Amber's affidavit basically was telling them that she downloaded the images and then actually had someone help her look at them, extract them, and she was able to physically see the information. So Amber Calmer, the person that ran the investigation, did this affidavit, and she said that I'm the detective with the Little Rock Police Department, and I've been there for 12 years. I do vice detail, and I investigate offenses of S crimes. I obtained training on torrential downpour, which is what they use to find this stuff. They say that in March of 2019, while using this, I detected a user connected to the network IP, which was his, sharing known images of CSAM over the network. Consequently, I utilized the torrential downpour program to make a direct connection to the offending IP address and downloaded 2 files containing CSAM. Specifically on May 14th, 2019, I downloaded from the offending IP address a video entitled Movie 216, and separately on May 15th, I downloaded a file entitled Marissa Zip. After downloading such, I viewed the images to verify that they depict CP and noted that the offending IP address geolocated to Northwest Arkansas. And then after downloading them, I contacted Homeland Security, and he agreed to pursue the lead on the offending IP address. And then she contacted the Internet Crimes Against Children Administrator, Lenore Palladino, to advise that I uploaded these 2 respective files to the ICAC data system and requested that she allow S.A. Faulkner to access them. So their argument is that they had these files in the IDS system and they're just ignoring that they're there, and they are. So their whole argument that Gerald Faulkner lied is without factual basis. So let me just pull up the main document so I can show you this. This one is super long, so we're not going to go over the whole thing. Oh, thank you so much for your super chat, sweetheart. I am not currently paying attention to my chat. So if I see a super chat, I will shout you out as soon as I can. But thank you, Run to Muck Girl 2, for your super chat. And I think I might have missed another one. I think I either missed that or a member. So sorry about that, you guys. Okay. So here is the main document. So it says that she loaded them and she contacted Lenore. After receiving the lead from him, Faulkner determined that the target IP was located to Ozarks Go, and they got this subscriber information. On October 29th, Howard Acock applied for it and got the warrant. Then they had to go back. They had 2 files that they downloaded, and they had to go back to get a second warrant because the first place that they went to was not actually his place. But here's what's interesting. On November 22nd, 2019, they did a forensic image of the hard drive, and thereafter all law enforcement processing analysis were conducted off the forensic image. They say that Kennedy completed his analysis and submitted a forensic report on July 24th, 2020. In October of 2020, CFA Kennedy provided a forensic image of the HP computer to HTIU. In doing so, he made the forensic image he sent to HTIU by duplicating his own forensic copy, as opposed to reprocessing Duggar's actual devices. So one of their arguments was that they did multiple searches of this, and they're saying that's not true. They did images, and then they did a second image of. They're basically using the same stuff that they had already taken. They didn't have to actually go back to the same hardware. They said that when they did the examination, the Linux operating system was created on May 13th. And they say the password to access the Windows operating system is desktop is Joshua JJD. Now that was the password to access the Windows operating system on the HP desktop was Joshua JJD, while the password access to the Linux partition was blah, 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 1988. They say both forensic examinations revealed that the Tor browser and the BitTorrent client uTorrent had been installed on the Linux on May 13th and May 14th. And then the forensic evidence supports that both programs were utilized to download CSAM, and that forensic evidence supports that the user of the HP computer deleted the images of CSAM from the device. They say that likewise, the MacBook on the hard drive was created in November of 2019, and all review and analysis were conducted on forensic image of the hard drives. From the forensic image of the MacBook, law enforcement determined he had backed up or synced his phone with his device. In the MacBook itself, law enforcement located numerous pictures and text messages that placed him at the car lot while CSM was downloaded, accessed, and viewed. And they said the evidence was all memorialized in a report of investigation submitted by Faulkner in April of 2020. Additionally, HSI discovered during this examination, Duggar used the password blah, 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 1988 or close variations for multiple online and cloud accounts, including his bank and social media accounts. They said that the iPhone was forensically processed, and he did not provide the one for his phone. So they had to, they were only able to achieve partial extraction, which was obtained on November 9th. And in March of 2021, the digital information or extraction pulled from his phone in November was provided to HTIU. And both examinations again revealed that the same images and text messages that were located on his MacBook were also on his phone. And both had revealed that Duggar used this password on numerous accounts. So there was a lot of discussion that they were doing illegal searches of his documents or of the hardware, and they're saying that everything was done based off of image recopy, so they weren't actually looking again at the evidence. And it's just fascinating to me that he used the same password for everything. Like, if you guys were going to be downloading, oh, thank you so much for your super sticker because of Vintage. If you were going to download this kind of stuff, would you use the same email address for your Linux partition as your bank one? Like, honestly, would you use the same one? Their argument is basically that the search warrant was completely valid. They say the government submits the search warrant was supported by probable cause, was executed in a timely manner, and did not contain material false or misleading statements nor admissions. And in the event this honorable court finds insufficient probable cause existed to issue the search warrant, the motion to suppress should nevertheless be denied because the Leon good faith exception applies. So there's an exception which says that information contained in the affidavit was sufficient to support a probable cause determination and did not contain false or misleading information. They said the evidence seized pursuant to the warrant should not be suppressed because the officers acted in good faith in relying on the issuance of the search warrant. They say that suppression is appropriate only if officers were dishonest or reckless in preparing their affidavit and could not have harbored an objectivity reasonable belief in existence of probable cause. Because the disputed evidence was seized pursuant to the warrant, it will not be excluded. Therefore, there are 4 situations with good faith exception to the warrant requirement does not apply. Those situations are if the magistrate or judge was misled by information, or where the issuing magistrate wholly abandoned the rule, where the affidavit is so lacking, and where the warrant is facially deficient. So they were saying that they were able to actually extract the information. And the person at the ICAC system, Lenore Palladino, stated that they actually seized the information. And they said that among its specific features, IDS allows officers to upload an image or video resulting from online peer-to-peer child-based CS exploitation investigations onto the system, document corresponding information such as IP addresses and peer-to-peer program involved, and maintains said files and information until removed from the system. As the administrator of the IDS system, I have the ability to grant access and share uploaded information with other law enforcement. They said that on May of 2019, Detective Amber of the Little Rock Police Department contacted saying that she had uploaded 2 files and that she had forwarded it to Gerald Faulkner. And so in their capacity as the ISA administrator, he then granted Faulkner access to the system. So the argument that they didn't have access or they had incomplete files, they're basically saying is not true because it was in the system. It was all there and they declined to look at it. So what are you going to do? Like, they didn't want to look at it, but it's there. I feel like they just wanted to throw anything at a wall and just see what would stick. So, okay, what was the other one? So we talked about the hands. This one is the appointment clause. I'm not going to go there yet. So then the next one would be suppressing the statements. So one of the things that his team wanted to say was that Josh's statements were, I'm sorry. Remember how they said that they got there and Josh said that he was like, wanted to call his attorney. And so he indicated that he wanted his attorney. And so their argument was that they denied him the right to talk to an attorney. Remember that one? Katie was in, I was actually featured in People Magazine, E, Page 6, the Daily Mail, Us Weekly, all the major tabloid outlets and all the major like entertainment magazines. Fox News didn't mention my name, and Entertainment. Oh, he's in Entertainment Tonight. Yeah, I was all over the place. So yeah, that was cool. Everyone should get vaccinated, and don't use that silly thing that okay. You were loving it. Yeah, it was awesome. All right. We are on, and I'm sorry. Oh, I see. Okay, so I got these. Oh, I see another super chat from Jody Mooney. Thank you so much for your super chat, Jody. I appreciate that. Okay, so the other one, remember, they wanted to suppress statements because they said that they denied his right to access to an attorney and they denied his Sixth Amendment rights. Okay, so let's talk. You know what I will say, and I just want to put this out there. I will say that I feel like a lot of these outlets specifically follow me for my Duggar content because I have a lot of contacts. Which, by the way, I'll just say this. I downloaded all this, I got all this stuff out and I was like, oh my gosh, this is serious. And I let Amy Duggar King know ahead of time that this live stream was coming out. And I let her know before any news came out what was in these things, simply because I didn't want her to find out through the media about Josh's hands being found in pictures. I thought that was actually a pretty serious thing that she might want to know about before, say, like watching one of my videos. So I gave her a heads up about that. I just didn't feel good about personally like putting that out on my channel and not letting Amy know. Okay. And she was horrified. All right. So let's talk about the statements. I do my best. I just didn't want to blindside her. You know, like, could you imagine this kind of information coming out and you're a family member? Like, I feel like you would want to know that ahead of time than having it come out on like People or whatever. It just felt like the right thing to do. So hopefully she was able to tell her mom. TMZ or Fox should hire you. Well, thanks. And thank you for becoming a member, Judy. Okay, so let's talk about the evidentiary hearing statements. I love that there's over 3,000 in the live stream too. And make sure you're giving these videos a thumbs up on the way. Super important that you do, so that this video can get out there, more people can see. You're not even interested. I'm even more interested in the register offender. And yeah. Okay. So it says at the present, they asked the court to suppress all statements allegedly made by the Duggar after he was asserted his right to counsel. And they say that the claim fails because he was never in custody for purposes of Miranda and the Fifth Amendment, neither initially when officers approached him nor subsequently when he consented to an interview. Moreover, his request to call a lawyer was in response to an announced search warrant, not an invocation of his right to have an attorney present during an interrogation. Finally, after being informed of his rights to counsel and to remain silent, Duggar knowingly and voluntarily waived such rights in favor of making a statement, and his motion is without merit and should be denied. So they said that they went to the property and they executed the search warrant there. And they said leading up to the lot, there was a gravel unpaved. There was 2 sheds-like structures on the premise, the smaller of which was the main office. They say the day there were multiple vehicles apparently for sale, and that when they arrived on scene, they executed the search warrant using a soft approach, meaning that they were in plain clothes, not tactical gear, and their weapons were not drawn nor brandished. And upon arriving at the lot, 4 agents, all dressed in plain clothes, protective vests, wearing insignia police or Homeland Security approached the defendant and two other individuals who were standing outside. So they said that the lead agents of the case exited their vehicles, identified themselves as federal law enforcement, and notified Duggar that they were there to execute a federal search warrant, and specifically explained that he had a search warrant for premises allowing for the seizure of items containing digital contraband, and that it was not an arrest warrant, and that neither him nor any other individuals were actually under arrest, and that they were all free to leave. So they said directly after giving that information to Duggar, he took his phone out of his cell phone, which was an Apple iPhone, and he stated he would like to call his lawyer. And Faulkner explained to the defendant that his device was actually covered by the search warrant and was being seized pursuant to the warrant, and that just using his one hand took the phone out of his hand with minimal to no physical contact. And then Duggar was informed by law enforcement that he could leave. And then Duggar, okay, so this is the funny part, is they say that Josh informed law enforcement that he might have to leave because his wife was pregnant and due to give birth at any moment. Faulkner acknowledged such and reaffirmed that it was fine for him to leave. So I don't think she was due to give birth at any moment in May of 2019. Mariella was born in November of 2019. Isn't that weird? What a dumb lie. He informed law enforcement that he might have to leave because his wife was pregnant and due to give birth at any moment. And they said that he acknowledged such and reaffirmed that it was fine for him to leave. So he lied about Anna giving birth, but Mariella was born in November of 2019. Does Josh literally lie about everything? They say that he remained on the lot, during which time he was neither physically restrained nor guarded. And then after securing the premises and starting the search process, Faulkner and Aycock approached the defendant and asked if he'd be willing to discuss the details of the warrant, to which the defendant agreed. Due to the ongoing search, the agents indicated that they could speak in Aycock's vehicle. And again, Duggar agreed to speak with them. Of note, when speaking with Duggar outside of the vehicle, the agents did not have any firearms brandished, nor did they physically direct or escort him into the car. And then in approaching the vehicle, they say that Faulkner walked to and entered the driver's side front door, walked to and entered the driver's side rear door, and the defendant walked to the front passenger door, opened the door, entered the vehicle. It says at no time when Duggar was inside did law enforcement officers stand outside, block, or guard the door. The doors to the vehicle were not locked during the interview. So he basically was not being held in there by any way. And they say immediately after they entered the vehicle, Aycock asked the defendant for his consent to record their conversation, which he provided consent for. After consenting and recording, but before Aycock could initiate recording the recording device, he then turned to his seat and asked, "What is this about? Has someone been downloading CP?" At that point, Aycock told the defendant not ask any additional questions until he could start recording the device. The recording begins with Aycock stating the date and time and then asking the defendant to state his name. Aycock begins informing the defendant of his Miranda rights. S.A. Aycock provided the defendant a copy of the HI's standard statement of rights form and read the form to the defendant out loud. And then this was the exchange that they had. So they said, if you decide to answer questions now, you still have the right to stop the questioning at any time or to stop questioning for the purposes of consulting an attorney, okay? All right, so what I'm going to ask you to do is sign right here. All you're saying is that you have read your rights. And he says, Miranda. And he says, do you understand what your rights are? And he says, okay, this is only for now. It's not for other. That's what Josh says. He says, sure. Like it says, if you decide to answer questions now, you still have a right to stop. And he says, okay. And at any time, but that's just you saying, and he goes, is this the CIA? Is this okay? This is U.S. Immigration's Custom Enforcement Homeland Security Investigations, all right? And he says, okay. He says, but you've assigned that you understand your rights. And he says, yes. Okay, so now that I'm going to ask you, are you willing to speak with us now without an attorney present? And he says, I mean, I may not answer everything, I guess, but yes. So they have Josh on a tape recorder or whatever, little saying he'll talk to him. And he says, I have more questions than I would like. Okay, all right. I have more questions than I would like. And he says, all right. So at the time he tells him this and he says, so he asks about how in the form it says into custody. He says, oh no, as we explained, this is a search warrant. So this is not an arrest and you are free to leave at any time. And he said, okay. And he said, all right, don't worry about that. And he said, that's just common language in Arkansas. And he says, as a matter of fact, if need be, if you'd like, I'll scratch this out. And he says, okay, yeah, that would maybe better. Just go ahead and scratch it out. I forgot about that. All right. So he voluntarily agrees to sit down with them. And while he's there, he wasn't being guarded. No one was telling him he had to stay. He even told them he was going to leave because Anna was pregnant. And then he sits down in the car with them. The first question he asks them before he can even hit record is, was someone here downloading CP? And they say that Duggar signed the form that he voluntarily agreed to make the statements. And during the interview, he confirmed that there was an internet service at the dealership, including Wi-Fi. He identified his personal cell phone as an iPhone 11. And he said that he had gotten that 2 to 3 months earlier. The cell phone has a passcode, but he didn't give the passcode to the cell phone. So compliant. Remember how compliant he was? He stated that he owns a password-protected laptop that was located in an RV on the dealership. Why does he have an RV on the dealership, and why is the laptop in there? Creepy. Okay, knowing all of this, right? They say Duggar stated that he owns a password-protected HP computer located in the main business office of the dealership that's also has the password for the device is written down in the office. He said the dealership employees use that computer. It says the DLs were done in May and Ivy was born. The investigators were at the lot in November. No, he actually was correct. Anna was pregnant. Oh, yes. I'm sorry. You're right. I'm sorry. Anna was pregnant. Okay. Yes, you're right. It was in November. Oh, thank you, Hope, for making my brain is not computing. So yes, Mariella was due. Okay. So he wasn't lying. Good to know. Okay. It says, Duggar stated that he was familiar with file sharing programs and torrent files, and he declined to go into specifics about his knowledge of these programs. He did state that his laptop, cell phone, and desktop computer may have peer-to-peer file sharing programs installed on them. So he says that it's on his laptop, it's on his cell phone, it's on his computer. He also stated that Tor is on one device. Up until that point, law enforcement had no knowledge that Tor, the Onion router, and is an online network designated to provide users with anonymous access to the internet that is sometimes referred to as the dark web, was at issue in the investigation. So he gave them information that they did not know they were even looking for. Thank you, Patty, for becoming a member. And thank you, Kate Rule, for becoming a member. I appreciate that so much. All right. Duggar inquired whether something has been downloaded on one of his devices. He then inquired whether the IP address was for the lot was marked and inquired about the scope of the search warrant. like, he's asking if the IP was marked by law enforcement. Like, were they tracking his IP? Why are you asking why your IP is marked if you don't have any guilt, Joshua? Huh. He's so dumb. Duggar later indicated to his knowledge that nothing was downloaded to or uploaded from any computer on site that would raise a red flag for the investigation. He also stated he was not denying guilt. He was not denying guilt. This is why they want this thrown out. Oh my God. But was not going to say anything to incriminate himself. Josh Duggar is not that smart. I blame the ATI education for this. Oh, I blame the ATI for this. Okay. He stated that when asked directly if he had seen images of CP involving children 5 to 10 years of age, he said, "I'd rather not answer that." The interview concluded and he left before the search of the premise was complete, and they did not arrest him that day after the search of the lot was over. After he made all of those statements, after he sat in their thing and gave them all of that information, he left. He left. Okay, you guys, I don't know. This should go without saying. But if you've got some federal law enforcement showing up at your house and they're knocking at your door and they're there for digital contraband, you just should not say a word. Zip it. Say, all right, cool. See you later. Call your attorney. Let them know what happened. Let your attorney handle it, Josh. He admitted to all of it. Like, I'm not denying that I'm guilty. I'm not denying guilt. I'm not denying guilt. I'm going to call an attorney, says Deb. Me too. I've got 4. Actually, you guys, I'm getting rid of 2 today. I was like tapping out of 2. I only have 2 attorneys now. I'm taking 2 of my attorneys off my payroll. So, you know, most business owners have attorneys, right? And he has Travis Story. He could have easily called him. Unbelievable. They say that Duggars asserts that the conversation with law enforcement was the product of an egregious, inexcusable violation of his constitutional rights. His argument is wholly inconsistent with the longstanding case of the 8th Circuit regarding police interviews. Without question, the Fifth Amendment and the Supreme Court proceeding in Miranda versus Arizona prohibit the government from introducing into evidence statements made by the defendant during a custodial interrogation unless the defendant has been previously advised of his privilege against self-incrimination and right to an attorney. Miranda warnings are only due when a suspect is interrogated by police in custody. A person is not in custody for Miranda purposes unless the person's freedom of action is curtailed to a degree associated with formal arrest. And the court must measure Miranda's custody agreement requirement objectively, evaluating how a reasonable person in the suspect's position would have understood the situation. In other words, the determination of custody depends on objective circumstances, not the subjective view harbored by this. So he had them scratch out that he was in custody, remember? Oh, Dauntless. ATI graduate over here. I blame the ATI for Josh. Thank you, Becca, for your super chat. Dauntless in life. She's the one that we talked to like in May, that she was in the ATI. She's a survivor of the IBLP. Okay. So they say that ACOC argues, here's what, I'll pull this back up. Okay. So it says, as argued below, it is clear the defendant was not in custody when he was approached by him, which prompted him to produce his phone and stated he wanted his lawyer. He likewise was not in custody when he voluntarily made statements to law enforcement. Lastly, even assuming that Duggar was in custody when he agreed to make those statements to agents in the vehicle, his initial question as to whether someone was downloading CP was unprompted and spontaneous, and he was thereafter advised of and made a knowing and voluntary waiver of the Fifth Amendment rights. So they didn't ask him that question. He literally just like blurted it out. So here's another question. Here's another like learning model here. If you are sitting down with law enforcement, you probably don't want to blurt out, is this about someone downloading CP, before they even have a chance to say anything. They always say that you're just supposed to have like a poker face and like pretend like you know nothing. So just be like, why are you here? I don't know. Nothing possibly could be going on here. Thanks, GC and Rebecca, for becoming members. We appreciate you. All right. Destiny says she can't wait for the trial coverage. Oh, it's going to be a lot. Destiny was like in chat before we even started, like clapping her hands, going, Katie, Katie, Katie. It was cute. All right. So Hillary says he clearly never had any sort of civics education about due process. Yeah. I still can't believe he admitted to so many things and Jem Bob is still paying for his lawyers. Exactly. Thank you for becoming a member. Lisa says he will learn the poker face in prison. Don't, you're having too much fun with this. I'm cracking up with you. This is really heavy stuff, you guys. It's so heavy that it's hard not to try to have a little bit of lightness here because, man, this is some tough stuff to read through. So they continue and they say that a person is not in custody for Miranda purposes unless the person's freedom of action is curtailed to a degree associated with a formal arrest. Courts must measure Miranda's custody requirement objectively, and a suspect's position would have been understood in this situation. They say that he had no reasonable person in Duggar's position would have concluded that his interview during the search of the car was custodial in nature. He was informed that he was free to leave or not under arrest. So the defendant was told from the very beginning of the search of his business and at every critical juncture thereafter that he was not under arrest and he was free to leave. When law enforcement first encountered Duggar, he directly before he produced his iPhone told them that he was on the premises pursuant to a search warrant, not an arrest warrant, and that he was free to leave. And shortly thereafter, Duggar told him that his wife was due to give birth at any time and that he might have to leave, which law enforcement again confirmed perfectly fine, but he elected not to leave. So they say, to be clear, down here, the agents did not confiscate his keys, nor did they stop him in any manner from leaving the lot. In fact, given that it was his car lot, he had multiple vehicles available if he desired to leave. After initiating the search, they approached him and inquired if he wanted to discuss the warrant. Approximately 2 minutes and 30 seconds into the interview, while reading HSI's standard Miranda form, the defendant asked the special agents about the line on the form regarding being taken into custody. And he says, no, we explained that this is a search warrant. This is not an arrest, so you are free to leave at any time. And they have this recorded. Jim Bob is paying for this. You know, do you ever just think like sometimes you have, here's what I just wanted to say. I got it. Remember how we talk a lot about on this channel about how Jim Bob is very worried about his family name, right? He's very concerned about saving the family brand, saving the family name, making sure that his name is in good standing. Part of me feels like if he would have just taken the plea deal, we wouldn't have any of these details, right? Now we have details because they didn't take a plea deal and because they did all of these motions. So if they wouldn't have done these motions, we wouldn't be talking about what he said, what was recorded, what was on his hands, right? We wouldn't know any of this if they wouldn't have filed these motions. But because they filed all these motions, now we literally know everything. And sometimes it's like you get what it's like karma, right? Like you're asking for it. Like you didn't have to do all of this. You didn't have to provide all of, but now that you've asked for all of this to come out, now we know all of this. Now it's all public. It's public record now. This could have just gone in a sealed. We would have never known. We'd have never known about the hand. We'd have never known about what he said to the police. Okay. I wonder if they're just ignoring the facts. Remember how they said they just wanted the truth to come out? You guys, if they just want the truth to come out like in black and white, they sat down with them with all of the evidence. All of it. He's paying for all of it. Intentionally tainting the jury pool to set themselves up for a mistrial. You think so? Jacqueline doesn't know how she fell into this, but I do a good job covering it. Well, thank you. Oh, that's what it is. You reap what it sows. Thank you, Sue Grammy. You're so cute. Susu. Oh, I love that. That's my sister-in-law's name, Susu. Okay. Yes, he was given a plea deal. The offer, they told him that if he pled guilty, he would get around 10 years. Cocky and dumb. Okay. So let's go back. I'm glad I did this on a live stream versus just like the constant stream of videos, because this would have been so much. Katie says, not a mistrial, a change of venue. Can I also just give a shout out to all of you that are new in the chat that I haven't seen before? Thank you for chatting. Thank you for being here. I see a lot of my normal chatters in here. I'm also seeing a lot of new time people. If this is your first time in chat, can you just hit a number 1 and let me know if you've ever been here before? If this is your first time, hit a number 1 so we can see how many of you are new here chatting. And we will welcome you because we love to welcome all of our newbies. So if you're new here, hit a number 1. Welcome, Ashley. Welcome, Rebecca. Wow, look at all of you. Welcome, Julie and Heather and Deidre and Jackie and Jesse and Kim and Ron and Deb and Anita and Viola. Janie, oh, it's going so fast. Daisy, Lauren, Jacqueline, Jody, Tara, Peg, Bodice, Linda. Oh my gosh. Marie, Lizzie, Deanna, Julie, Robin, Lauren, Mama Bear 58, Jessica, Linda, Daniel, Angie. Oh my gosh. Okay. There are so many of you new that are chatting. We love you. We do hope that you come back. We have a very good family here. Everyone's very kind, and I definitely recognize your name, Christy, and I know you've been here forever. Some of my longtime folks have been here forever. August Gem has legit been here since I think I had 2,000 subscribers. Jesse Bear has been with me since before I had a YouTube channel. All right, so I have more people watching than subscribers. Oh no, I have almost 180,000 subscribers. So I definitely have more subscribers than I have people watching. But yeah, but I'm so glad to see so many of you new here. So glad that you're chatting, Jacqueline. All right. Thank you for your super sticker, chat. Okay. Oh, Raz says, I love you. I love you. Okay. One of my, Kathleen, thanks for becoming a member. One of my moderators can give you a link to becoming a member. Let's get back at it. All right. So the defendant was told that from the very beginning that he was not under arrest and he was free to leave. When the law enforcement encountered him, okay, we already did this. Agents refused to provide him with a complete copy of the search warrant until after the search was completed, further suggesting that he was not free to leave and had to stay. The defense was apparently failed to realize that at the conclusion of the interview, Duggar did in fact leave the premise and instructed law enforcement to leave the return with his employee. Okay. Josh left before they were done. Under these circumstances, there's no plausible claim that the defendant was not advised that he was free to leave the premise and that he was not under arrest. He told them to leave the rest within his employee. Do you wonder, honestly, this is my question. Do you think that when he was sitting down with Justin, that he just left out these critical details? Or do you think that Justin, his attorney, is just ignoring these critical details? All right. I feel like he's either lying to Justin or Justin's just trying to play some sort of card. All right. Whether Duggar possessed unrestrained freedom of movement during questioning. When the agents initially approached the defendant, they were executing the search warrant using a soft approach, meaning that they were in plain clothes, not tactical gear. Their weapons were not drawn. Even though they produced an iPhone, which is without question an item covered by the scope of the search warrant, law enforcement had minimal contact with him. And when seizing the device pursuant to the warrant, and that he told law enforcement he might need to leave during his wife being pregnant, and was told again by law enforcement that he could leave. And at no time was the defendant handcuffed, restrained in any way. Even though he was elected to stay on scene, he was not guarded by law enforcement and was allowed to free roam the premise. And they said when law enforcement approached him and asked if he wanted to discuss the warrant, he was still outside, not handcuffed, not guarded. When he indicated that he was willing to speak with the agents, he freely walked, meaning no one touched him or escorted him. He got into his vehicle, simply walked there on his own volition, opened the door, sat inside. The doors of the vehicles were not locked. No guns were drawn. The doors were entered. The vehicle was not guarded. He was told he was free to leave while he was at the conclusion of the interview. And he factually left while agents were still on the scene. In similar circumstances, the Eighth Circuit reaffirmed a district court's conclusion that a defendant was not in custody for purposes of Miranda when interviewed in a law enforcement vehicle. And they say he was not in custody and entitled to Miranda's warning prior to his vehicle confession because the defendant willingly entered Sergeant Kavanaugh's vehicle, voluntarily responded to the questions, and presented no evidence that he was restrained as though he was under formal arrest. While the defendant does not address this factor, this court should conclude that Duggar's movement was not limited in any way by law enforcement during the voluntary interview. They say whether Duggar initiated contact or voluntarily acquiesced to official requests to respond to questions. They say that law enforcement executed the warrant at the car lot and encountered Duggar himself. And when they approached him, he was outside his business, remained outside while the agents asked if he wanted to discuss the search warrant. He consented. He then told them that the interview could happen. He was then told that the interview could happen in the car, which was parked in close proximity to the main office due to the ongoing search. And he walked to his own volition to the passenger side, opened it, entered the car. And it says that the defense states the motion that the agents physically escorted him to a government vehicle. The defendant does not cite where he elicited this information, and the government remains unaware of a basis for that claim. It is incorrect. Agents could even begin recording, before he could even begin recording the conversation, he asked an impromptu whether someone was downloading CP, and since the defendant took the initiative to make statements to law enforcement without questioning, which cuts against a finding that the interview was custodial. Nope. They already offered him a plea deal. Oh, thank you so much. Hi, Katie. My theory is the importance of the hand ID is because his hands may be visible in active photos committing a crime. What do you think? I think the hands are because of it being on the computer desk, but that's just me. They didn't specify. If it's in images, you guys, that makes me feel physically ill. I would prefer that he just was on the desk, but again, we don't know. Whatever it is, those hands place him at the scene effectively. Okay, so, but to answer this question, they already offered him a 10-year plea deal and he declined. So he's not going to, it sounds like he's not getting a 6-year deal. And generally when you get a plea deal, they're giving you like a 40% reduction, meaning they were like likely expecting to sentence him to 16 to 20 years, I'm guessing. All right. So they said that when law enforcement approached Duggar, they informed him that he had a search warrant for the premise and that he was free to leave. This is a correct statement. No arrest warrant was obtained by law enforcement to search prior to the search, nor did the agents seek prior approval to arrest anyone that day. When law enforcement approached the defendant again, he was outside and they simply asked him if he wanted to discuss the promise of the search, the purpose of the search warrant. The remainder of law enforcement's conversation with defendant is recorded, and the interviewing agents are professional and courteous throughout. When Duggar stated during the interview numerous times that he did not want to discuss certain topics, law enforcement acquiesced to his preference and did not press him any further. There is no assertion by the defendant, nor are there facts to support that law enforcement lied, misled, or engaged in a manipulative tactic in any way. According to, on this record, the court should conclude that the interviewing agents in this case did not use strong arm tactics or strategies during the conversation of the interview. They say, in fact, at the point in which the agents encountered Duggar, and even when they interviewed him, they only knew the facts outlined in the search warrant affidavit. The forensic evidence supporting his arrest was not even discovered until after a subsequent off-site forensic evaluation of the HP computer seized from the defendant's office was on the car lot. So they didn't even know if he was involved in it until they actually got it off his computer. So he wasn't technically like a suspect. They just knew that it was happening here, but it could have been anyone. They say that the officers swarmed the premise while executing the search warrant. Based on Faulkner's testimony at the detention hearing, this is not how it happened. They say they described the soft approach when the 4 agents executing the warrant took the day, meaning there was no weapons drawn. The agents calmly told the defendant upon the arrival that they were pursuant to a federal search warrant, that was not an arrest, that he was free to leave. While law enforcement factually executing the search warrant, it's important to note that this was a public business as opposed to a private residential setting, and the defendant was outside the entire time. And once inside the vehicle, Duggar was alone with 2 agents who were not brandishing weapons, who repeatedly made it clear to Duggar that he was free to leave and did not have to answer any questions. Given the amount of leeway that the defendant had in moving about his car lot and deciding whether to speak to law enforcement, this court should conclude that this fact also supports a finding that the defendant interview was not custodial. He was not in custody, you guys. Finally, it is indisputable that the defendant was not arrested at the end of questioning. In fact, he elected to leave the premise after this interview, but before the search was complete. Based on the analysis of the factors detailed above, the court should conclude that Duggar was not in custody. Okay, and they say that Duggar's request to call a lawyer was not in response to a police interrogation. So the Supreme Court has emphasized that the rights offended by Miranda and its progeny will only apply when the defendant is made at minimum some statements that can reasonably be construed to be an expression of a desire for the assistance of an attorney in dealing with custodial interrogations by the police. So they emphasize that the Sixth Amendment right to counsel during a judicial proceeding does not constitute an invocation of the right to counsel under Miranda. So they basically are saying that if a suspect makes a reference to an attorney that is ambiguous or equivocal in that if a reasonable officer in light of the circumstance would understand only that the suspect might be invoking a right to counsel, as such, a suspect must articulate his desire to have counsel present sufficiently clearly, and that the reasonable police officer in the circumstances would understand that the statement to be a request for an attorney. There's no requirement that an officer must ask clarifying questions when a suspect makes an ambiguous statement regarding counsel. Applying these principles, they say that maybe I should talk to a lawyer was equivocal and not an invocation to the right of counsel for purposes of Miranda. The Eighth Circuit held in United States versus Havlick that the defendant's statement to the police is, I don't have a lawyer, I guess I need to get one, don't I, was insufficient to trigger an obligation to cease questioning. So they say that the defendant purported invocation of his right to counsel must only unambiguously reflect that the defendant is seeking the assistance of counsel, but the purported invocation must also unambiguously reflect that it's for the specific purpose of having counsel present during the interrogation. So they say Duggar produced his cell phone at the onset of the execution of the warrant, stated that he wanted to call his lawyer. It was not in response to a custodial interrogation. In fact, law enforcement just arrived on scene and told the defendant that he had a search warrant for the premise, but that he was free to leave. At that point, Faulkner had not stated anything about conducting an interview, what the investigation entailed, or who it involved. In fact, Faulkner at that point had asked the defendant no questions. He simply stated why they were at the car lot that day. While the defendant may have wanted to alert his attorney to the presence of federal agents on the present, there's nothing about the context in which Duggar made the statement regarding his attorney that could rationally be interpreted to reflect that he did not wish to speak with the federal agents that day without counsel. And again, when agents did approach Duggar about speaking with them, he was apprised of his Miranda rights, signed a statement of rights, form acknowledged that he understood these rights, and advised the interviewing agents in response to direct questioning that he was willing to speak with them without an attorney present, but that he may not answer all the questions. Under these circumstances, the defendant's initial statement regarding an attorney can only reasonably be interpreted as a response to the execution of the warrant and not a response to whether he was willing to give a statement to law enforcement. Accordingly, the defendant's invocation of his right to counsel, to the extent can be only described as such at all, was ambiguous. So they're basically arguing that they weren't trying to interrogate him at that point, and he wasn't saying, like, I want to talk to an attorney because I'm afraid you're going to take me into custody. They're basically saying they didn't have a reason to even assume that he was the assailant or the suspect in this point. So it says, because it is clear that this defendant was not in custody, any notion that he invoked his Miranda's right is invalidated by his non-custodial status. As numerous courts have decided, a defendant's anticipatory invocation while not in custody is no way invokes one's Miranda rights, because those rights do not attach one not in custody. So they say in a case where the circuit found that the law enforcement could not speak to a defendant upon the arrest because he previously invoked Miranda rights in a chance non-custodial encounter with law enforcement, they rejected that conclusion. So they say Duggar was informed of and validly waived his Miranda rights. They said even though the defendant was not in custody at any point during the search of his car lot, they went above and beyond their obligations and given the circumstances and advised the defendants of his rights. While in this motion, Duggar asserts that there is simply no evidence to suggest that Duggar knowingly, intelligently, and voluntarily waived his constitutional rights. The defendant's own actions and statements during the search prove that he knowingly, intelligently, and voluntarily waived his rights and agreed to speak to law enforcement. The defendant, in concert, that waivers the constitutional rights not only must be voluntary, but must knowingly intelligent acts done with a sufficient awareness of relevant circumstances and likely consequences. So there was no accusations or supporting facts to reflect that Duggar was coerced, threatened, or intimidated by law enforcement. Indeed, his interview with law enforcement was recorded and produced to the defense. The defendant was pointed to no instances in the recording in which law enforcement coerced or threatened him. And equally clear is that from the beginning of the interview, he elicited information and asked questions to make sure he understood the rights that he was waiving. At the onset of the questioning, for example, he specifically read and provided a form advising him of his rights to remain silent and to an attorney, which he acknowledged and signed. As the record interview reveals, a mere 1 minute and 24 seconds into the recording, he confirms with ACOC that Miranda form and his waiver of rights only applied to the interview conducted that day, and that 30 seconds later, defendant tells the interview agent that he may not answer every question, and that further defendant had the agents cross out the section that said he was in custody, reflecting a clear understanding on his part of the circumstances in which he was speaking to law enforcement and his constitutionally protected rights. And just as he indicated previously, he repeatedly declined to answer certain questions during the interview, declinations that law enforcement respected, reflecting on the defendant voluntarily waiving of the rights with a comprehensive understanding of his rights that he was waiving. If the court concludes that the defendant was in custody for the purposes of this interview with law enforcement, all available evidence indicates that he knowingly and voluntarily waived his rights, and his motion to suppress statements should therefore be denied. So they're saying, like, even if he was in custody, he knew that and he still declined counsel. So after reading their argument and then knowing what Josh's attorney is saying, where he was aggressively escorted and he was in custody, do you think that he was in custody? Do you think that the police were trying to get information from him? Do you think that they were violating his constitutional rights when they told him that he was free to leave? Do you think that it was a violation of his rights while he was there and he was walking around the car lot and no one was guarding him? Mackenzie's 12. While he was walking around the car lot, do you think that he was in custody? Kate says he's playing victim as usual. They were asking questions. He opened his mouth. All right. No rights for predators. If he was a fraction of a man that his dad thinks he'd do the right thing and divorce Anna, at least for the kids' sakes. I agree with that. Was a fan of the Duggars. Anna, what are you doing? Parents are monsters, just like Josh. Scared for the rest of the family. So in 19 pages are saying that he was not forced nor things went against his rights, which technically did not have since he's not in custody. Correct, Valencia. Correct. And you appear brand new. Welcome. Melody says they let him leave to go home with his kids. That makes me so sad. What about the kids' rights? I know, right? What about the kids' rights? Artsy Nurse says Miranda could work for a baby name, though. Help remind them of this difficult time. Oh my gosh. Huh. I hope they don't name Miranda. And Danielle says, I'm okay with Josh spewing out comments that steer towards his guilt. He needs to go away for a very long time. I agree. Okay. Even if he gets off, these people don't stop. It's a disease. He will continue to do this and get caught again. I know these predators, they're hard to, nearly impossible to, what do you call that? Reform or what is it when you do something again? Not rehabilitate. Rehabilitate. That's it. Rehabilitate. It's impossible to rehabilitate these people, right? If he was in custody at any time, there would be an arrest record, correct? Yes. He would have been arrested if he was in custody. Is it weird that I'm finding a little pleasure in the family imploding? They played it off as religious, humble people for many years. He will not save the family brand. Now it's over. You know, you get what you ask for, or you get what you pay for, right? So he wanted everyone to have all of this information, and now we have it, and it's in black and white. And you guys, okay, I need to know, we're at an hour and a half right here. And there's there's two more motions, you guys. We did the statements, we did the hands. The appointments clause, that one I have, but I don't want to go over that one today. I have preserve potentially exculpatory evidence. All right. And then the search warrant, to throw out the evidence from the search warrant. So there's two items left. And I need to know, I'm not going to do the appointment clause one because that is so long. That's like 3,000 million pages. But I have one about those witnesses that he interviewed and wanting them to throw out those, dismiss the whole case. Are you guys still in for, say, another half an hour of this? Are we at our limit? Tell me what you want me to do. And tell me if you, tell me, I don't even know how to do this. Like, do you want to keep going? Yes. Or do you want to stop? Keep going? Keep going? Okay. All right. So let's keep going. All right, I need 2 seconds though. I'm going to do a brief intermission. Give me 2 seconds and then we will do the next one. We're back. Woo! All right. I'm here. I had to use the restroom. Martha, thank you for your super sticker. And Becca, we all know it's just getting to the bottom of it. We all know, come on, people, he learned from it somewhere. Yes, keep going. Okay, Becca, we will keep going. Thank you for that super chat, sweetheart. All right. Does everyone have their beverages? Did you get your snacks? Did you go to the restroom? You guys, I did an hour and a half of some really hard reading, and I hope it was mildly entertaining for you. I've got my Katie glass with a Frida Kahlo quote, which says, at the end of the day, we can endure much more than we think we can. So cheers, everyone. Oh, yes, I will get the membership link. Miss Jessie wants the membership link. Let me. And I want to thank you guys for, they've already limited this for my monetization, but I could probably be able to get that back. Anyways, here is the membership. Thank you guys for being so, what do you call it? Not lying or not being mean to each other. Thanks for being nice to everyone. Thanks, everyone, for being nice to each other. Thank you for all of your hard work. You're welcome. Thank you, super sticker. Thank you, Carla, for your super sticker. We appreciate all of your stickers tonight. This is amazing. I'm not gonna lie. I think I spent over $100 on court records today. So this is for your information here. But I bought it all just for you. All right, Jessica, thank you for becoming a member. All right, let's get on to. We just finished suppress the statements, failure to preserve exculpatory evidence. All right, you guys. So one of the things, Momin, thank you for your super sticker, and thank you, Heather, for your super chat. Yes, it is so expensive. One of the documents is 200 pages, which I didn't go over because it's how the network, the BitTorrent stuff works. And it was part of that suppression of something. And I just felt like it was going to go way over all of your heads. So I was like, but I still bought it. But yeah, one was 200 pages. Mama of 6, thank you for your super sticker. All right. We always appreciate your support. All right, let's get on. Oh, and Maureen, thank you again. Let's get on to opposition to the defendant's motion to dismiss for failure to preserve potentially exculpatory evidence. Who's ready for more? Everyone ready? Let's go. So we have 1,100 likes already. This is amazing. I am loving this. Thank you. And Tracy and Heather, thank you for becoming members. And Nana, welcome to membership, all of you. We love you. Thank you. All right. Yes. Love to all the super chat new members. Keep up. I can't keep up. You're amazing. Exactly. All right. Hi. Oh, Love Rue says she's ready to go. All right, let's go. Let's go. Yeah. All right, let's go. All right, so they say that they want to suppress failure to preserve potentially exculpatory evidence. So this is in relation to the 3 witnesses. So remember, we told you that there was 3 witnesses that they claimed that they interviewed and that Josh wanted to pin the blame on. Now, here's the thing, you guys. I was wondering if he was going to try to pin it on one of his brothers, but I read through this 2 times before we went live, and I cannot, for the life of me, pin these comments to one of his brothers. In fact, I don't think that any of the people they interviewed were his brothers, unless the second witness that had never worked for him did. But they don't sound like his brothers. Because one of them was incarcerated, and that certainly was not his brother. None of his brothers have technically been in jail that we know of. I mean, but there's no court records. So anyways, would they hide that from us? Oh, what if they went to jail under a pseudonym? Could you imagine? All right. All right, so they say at 3 p.m., law enforcement executed a federal search warrant. The warrant was authorized to search the car lot and the 2 small shed structures on the evidence based by the user of the internet IP address assigned to the lot that had shared those images. They arrived at the premise. They found the defendant, who owned the dealership since approximately 2018, and 2 other individuals. They determined that one of these individuals, identified as witness number 3 in the defendant's motion, worked at the car lot, and they interviewed him. And then the individual told law enforcement that he began working at the car lot in June of 2019, and that he did not access the internet at work, and that the computer in the office on the car lot belonged to and was only used by the defendant. And they also told law enforcement that he was very inexperienced with computers and did not have social media accounts. After obtaining his consent, they reviewed his phone on the scene without the use of a forensic tool, found no evidence of criminal activity on it, and returned the device to the individual. So this would have been witness number 3, they're saying that they interviewed. So following, and that apparently happened on the day of the search. So whoever was there with Josh on the day of the search. And he started working in June. The content was allegedly downloaded in May. Okay. They said that they interviewed multiple individuals. One of the individuals referred to as witness number 1 was interviewed on December 16th. This individual told law enforcement that he had purchased multiple vehicles from the defendant, but denied ever entering the small office on the defendant's car lot without an employee present. He demonstrated no familiarity with peer-to-peer file sharing programs and said that he was not in the vicinity of the car lot in May of 2019. The individual allowed law enforcement to manually review the contents of his cell phone, which he had recently purchased in October of 2019 without the use of a forensic tool. Law enforcement found no evidence of child abuse material and returned the device to the individual. So this was witness number 1. And that was in December of 2019. Now, here's my question. Remember how the Duggars got into a really big fight with Paul Caldwell? The Caldwells split from the Duggars. Do you think Paul Caldwell could have been witness number 2? Because he said he bought cars from them, didn't work for them. Do you think Paul Caldwell could have been one of these witnesses? Witness number 1 or witness number 3 doesn't sound like a brother. Witness number 2 doesn't sound like a brother to me. Just that he someone that bought stuff from them. I was wondering if maybe Paul Caldwell was interviewed as a witness. Paul Caldwell did some work. Courtney says, I think the rift is directly linked to the raid. It's either linked to him or to Joseph, right? And I feel like Caldwell is a mechanic, So he would have interactions with Josh. I don't know, maybe. It could be Paul. All right. Remember Paul's like dowry thing? That was so creepy. Joe seems like a good guy. Everyone I talked to around the Duggars, they say that Joseph is a good dad and a good husband and a good person, and they say John's a good person. That's it. And someone told me that Josiah creeps them out, and another person said that Josiah is really like boisterous and all over the place and very spastic. So Paul is Kendra's dad. Yes. Yes. All right. No, they did not raid the house that they lived in. I looked up the address, and that was not the house that Paul and Christina were living in. So no. Yes, Paul is Kendra's dad, Kendra Duggar's dad, Joseph's father-in-law. He's the hot dad on the block. He also passed out flyers that told gay people they weren't real. So he's super homophobic and kind of a jerk and whatever. But clearly, if I was brought into something like this, I would be so annoyed, especially if I did nothing. So, because here's my question, is knowing that they want to place it on one of the witnesses, that's why I feel like maybe Paul is a part of this, because maybe they're trying to pin it on Paul. You know what I mean? And like, all right. Defendants, okay, so then they said that on December 20th, they interviewed another individual, witness number 2, that advised that he worked for the defendant from 2017 to September of 2018. He left to start his own business. He told law enforcement that the internet at the car lot was password protected and not accessible to the public. He acknowledged using the defendant's computer when he worked at the car lot, but demonstrated no familiarity with peer-to-peer file sharing programs. Denied ever accessing the P word on the computer, and he advised law enforcement that the defendant's computer at the car lot had a program known as Covenant Eyes. On it, which would notify the defendant's wife if the device was used to view P word. The defendant told him he struggled with the P word addiction, and finally this individual reported that he did not believe that witness number 1 was computer savvy, and that witness number 1 had never mentioned using peer-to-peer file sharing software. The individual also allowed law enforcement to examine his cell phone during the interview. Law enforcement observed no evidence of CSAM on there. Law enforcement did not create a forensic report or a forensic image of the device. And they said since speaking with him, they reviewed information indicating that he was incarcerated the entire time frame in May of 2019 when the user of the car lot's IP was sharing this material. So witness number 2 is the felon. Got it? So witness number 2 is that felon, the one that was incarcerated. He worked for them from 2017 to 2018. Witness number 1 claimed that he had no social media, right? Oh, wait, no. Witness number 1, multiple vehicles, never been on prison, no peer-to-peer file sharing programs. Okay, so witness number 1 and witness number 2 know each other. So who in the Duggars circle is like going to jail? Who are they hiding around us that we don't know that's been in jail? It says that according to the records obtained from the defendant's business, the individual that worked for him in 2019 received his first paycheck on May 31st. But there are no records of payment to an employee who worked at the dealership on the 14th or 15th. and when the user of the lot's IP address was sharing CSAM material over the BitTorrent network. So none of them were there. But this person was actually incarcerated. So being a prison minister and incarcerated are two separate things. Okay, so that says the defendant now moves to dismiss this in its entirety, that our government was required to seize for him the above three individual cell phones without any semblance of legal process, extract all the data, content from those devices, and produce the complete forensic images, copies of those devices to him. The defendant asserts that the forensic images, copies of these phones might have contained information indicating whether the owners of the devices used the dark web or peer-to-peer file sharing software. And according to the defendant, the fact that the government has not provided him with the forensic image copies and developed his defense for him constitutes a due process violation that can be remedied by dismissal of all the criminal charges. And they say that the defendant is incorrect. The government cannot produce what it does not possess. The defendant's suggestion that the government somehow failed to preserve forensic image copies is baseless. As detailed above, 2 of these phones were manually reviewed, which could not result in the creation of a forensic image copy, and the third was not imaged either. Even assuming for the sake of argument that the opportunity to collect information qualifies as constructive possession of information, the defendant has failed to establish that his due process rights were violated by the absence of these forensic images under controlling Eighth Circuit precedent, because image copies have no apparent or potential exculpatory value, and because law enforcement did not act in bad faith and comparable evidence is reasonably available to him. In fact, because of law enforcement's efforts to thoroughly investigate this matter, the government has reason to believe that none of these individuals were present on the car lot when the computer was used. So one of them didn't work there yet. One of them was incarcerated. One of them was not employed there anymore. And the other person was not on the premise. So if none of them are on the premise, how are they guilty? Riddle me that. Riddle me that. Riddle me that. Okay. I'm thirsty. All right. As an initial matter, the defendant's motion incorrectly frames the issue. The government did not seize the cell phones belonging to these individuals, nor did it use any forensic tools to create forensic image copies. The government had no reason to seize those phones to create images. There was no evidence that these individuals were present at the car lot in May, and reviews of their phones uncovered no evidence. In fact, as discussed above, there is significant evidence that these individuals were not on the car lot on the relevant times. The information gleaned from these individuals was documented in reports provided to the defendant, along with recordings of the interviews of these individuals. And of course, the government advised the defense that no forensic images of these devices were created during the investigation. Put simply, the government cannot preserve what it does not have. In this case, forensic images of various cell phones belonging to individuals who are not present on a car lot during the relevant time frame, and the government has no obligation to take investigative steps based on what a defendant might want at some later date. So they can't go back in time and do something because he might want this information in the future. Rejecting the defendant's speculation that the government intentionally refused to develop evidence related to other suspects, and noting that the prosecution is not required to disclose evidence it does not possess. So he claims in another motion that the government treated the warrant to search his used car dealership as carte blanche authority to storm into the business nearly 6 months later, seizing everything in sight, which is, of course, irreconcilable with his criticisms of the government's investigation during the search in the instant motion. Yeah, so they're basically saying that the government took everything in sight, but then they're also saying, you left this stuff. So in one motion, the government was horrible and did everything. And then the next motion, you left this out. You guys, nobody. Yes, this will be uploaded. Nobody is more prosecuted or more victimized than Josh. All right, so it says a review of this case relies on this one thing. In the Ninth Circuit, found a defendant's due process rights were violated where law enforcement recorded or a video of a defendant's arrest solely in its possession despite formal request to preserve it. In that case, the video was critical to corroborating a duress defense and her claim that she intentionally attracted the attention of law enforcement when she was arrested to get help. In this case, on the other hand, the government did not save or delete the forensic images copies of the phones because both parties know there was no reason to create forensic images of those devices in the first place and that asserted evidence did not exist. So they say that there was nothing to save, no evidence. And there's Frida. Everyone's been asking where Frida is. They say the defendant's motion is nothing more than an after-fact criticism of an investigation that he has resulted in a federal against him and criticism that he will no doubt seek to inject into the trial in this matter. Should this case proceed that far, his perceived dissatisfactions with the investigation, however, are not grounds for dismissal of the indictment. I like that part there, you guys. Nothing more than an after-fact criticism. So Josh is like basically with his motions kind of doing a commentary. He's like a commentary channel. He's doing his commentary of the police work. Police don't get warrants to take info from every person they speak to during an investigation. That's absurd. Exactly. All right. Based on the defendant's motion, it appears that he may be asserting an alibi defense. The government has received no notice of his intent to introduce such a defense and formally requests that the defendants notify the government of an intent to alibi defense pursuant to Federal Rule Code of Criminal Conduct. So they think that he's going to say that his alibi is that somebody else did it. Okay. They say that there was no evidence. They also say they failed to explain what was exculpatory, that the government acted in bad faith, that the evidence is otherwise unavailable. With respect to the first prong, there was and continues to be no reason to believe that the 3 phones referenced in this motion contained exculpatory information. And omitted from the defendant's motion, law enforcement had no reason to believe that any of the 3 individuals on the cell phones referenced in the motions were present at the car lot on May of 2019. So witness number 1, for example, denied being at the car lot in May 2019, demonstrated no familiarity with peer-to-peer networks, a stark contrast from the information the defendant provided to law enforcement regarding his familiarity with the peer-to-peer networks and the dark web during his voluntary interview. This individual also consented to a manual review of his phone, which he informed law enforcement he obtained in October of 2019. They discovered nothing evidentiary during the manual review, and the phone was not seized. The forensic image of the devices were not created. So their argument for witness number 1, nothing on his phone, he wasn't there, and he does not know anything about peer-to-peer networks. Mr. Duggar at the scene, peer-to-peer, dark web, Tor browser. I mean, Josh Duggar's diarrhea of the mouth got him in trouble. With respect to witness number 2, this individual informed law enforcement that he stopped working at the dealership in 2018 to start his own business, a fact corroborated by other evidence. He denied having any familiarity with peer-to-peer networks, advised law enforcement the computer at the car lot had a program known as Covenant Eyes installed on it, which would alert the defendant's wife if the device was viewing pornography. In explaining the detail, this individual noted that the defendant told him he struggled with this addiction. This individual likewise consented to a search of their cell phone, which also completed on the scene. The examination consisted of a forensic review, which uncovered no evidence, and law enforcement has since received information that this individual was incarcerated during the period charged in the indictment, which is the same period in which the defendant's IP address shared the content. So witness number 2, who worked there from 2017 to 2018, he was in jail. Witness number 1 had no familiarity. And then witness number 3 began working there in June of 2019 after this happened. And records obtained from the defendant's business confirm that this person was not working at the car lot during those times. And the individual also demonstrated an extremely limited familiarity with computers, and a manual review of the cell phone turned up nothing. So I don't think any of these guys are his brothers. Do any of these sound like his brothers? None of them sound like brothers to me. I don't think any of these are his brothers. One of them is probably that Randy guy. But I don't think any of these are his brothers. So further, because the thoroughness of this investigation, the government has obtained evidence indicating that none of these people in the motion were present at the car lot in May when the defendant's IP was used to share this content. They also obtained and provided the defense evidence establishing the defendant was present at the car lot at the time. And indeed, the car lot belonged to the defendant. And based on his own business records, he appears to have been the only paid employee on the dates his computer was used to download the stuff. So the dates that he was there doing this, he was the only person working. Obviously, are you going to download the stuff when you've got Randy sitting there watching with you? You know Randy's going to go back to church and tell everyone what you were doing. Josh is sneaky. He's not going to do this around anyone. They say forensic evidence recovered from his devices confirmed that he was in fact on the car lot when his computer was used. Rather than confronting this evidence, the defendant is seeking the extraordinary remedy of dismissal of the entire indictment on the complaint that the government failed in 2019 to predict that the exact contours of his defense strategy in 2021 and tailor its investigation to support that strategy. While it's an unsurprising litigation tactic, this sort of retrospective critique of the part of the defendant falls well short of satisfying his burden of proving the government acted in bad faith. I actually kind of like how sassy the government is here. They seem like so annoyed. Like, Josh, you are ignoring the fact that we found it on your phone or we found it on your computer and we have photos and we gave your defense all the evidence and you guys know what we found, and you're ignoring all of that and you want to say it's these 3 people when you know you're there. Like, it's mind-boggling that Jim Bob has wasted so much money and time of the government on this. They say there's no evidence to conclude that the government acted in bad faith. The defendant has failed to offer proof of an official animus or a conscious effort to suppress exculpatory evidence. There's no reason to conclude that the images of these 3 individual phones might contain information, evidence related to the BitTorrent peer-to-peer file sharing network and the dark web, and the geolocation data placing the devices on the car lot on 14 and 15. There's ample reason, however, to conclude that they do not contain such evidence. In other words, law enforcement had no reason to seize it, as all available evidence made clear that they contained nothing of evidentiary value. So he wants everyone to ignore what they found on his computer and be like, no, it's that guy. It's that guy. It is that guy. How does this coincide with the SW case? I don't know what SW means. And they given, and how can Anna, like, is Anna this stupid? Do you think that Josh is just not letting her see this information? Because there's those emails where they sat down and told them everything they had, gave them everything, showed them everything. Oh my God, you guys. The appointments clause one, that's another 20 pages. I don't think I have that in me. So Anna is brainwashed. Oh. Yeah, this has nothing to do with Summer Wells. My biggest fear is for his kids. Can law enforcement step in to ensure their safety, knowing that John and Shanann will do anything to cover it all up? You guys, I'm starting to think that the Duggars have the kids because they're the safe people. I'm kind of starting to wonder if CPS might have told Anna that she might lose the kids, so she might want to have the kids with a safe family member. I feel like in a case like this, that could have happened. CPS cases are always confidential. And I'm pretty sure the kids have probably... No, Anna's not the guilty one, but Anna has a duty to keep her kids safe. And if Josh has undue influence over her, the kids might not be safe. So look at LE and everything else. Okay. They are grasping at stupid straws. They probably do have an ad litem. That was already in one of the things. So I know that the court has appointed something like that because they already stated that his children could potentially be witnesses in this. That was part of the protective order. So Anna knows the boys, know the girls, know everyone knows. Yeah, I don't know. Jim Bob wanted all of this information to be hidden, but now I feel like with everything out there, I feel even more confident that he's guilty. Oh my gosh. The court should deny defendant's motion to dismiss the indictment due to an alleged appointment clause violation because the pending charges were properly brought by a grand jury and endorsed by the United States Attorney's Office in the Western District of Arkansas, and authority of the HSI agents involved in this case do not derive from the Secretary Department of Homeland Security. am finally acting. Okay. There's like 18 pages on this appointments clause. And I just don't know. I feel like if we don't cover it, then it's just like legitimately not covered. And I feel like we might as well just get it done with. Who is ready for the appointments clause one? Who wants to give me some motivation? Okay. All right. So I'm going to see if I can skim this. So basically, their argument is that the court need not reach the constitutional and statutory questions raised by his motion because the grand jury is the ultimate investigating authority that returned the indictment and is the U.S. Attorney's Office who is authorized by statute to prosecute this case. Furthermore, regardless of whether the position of an acting secretary was properly filled at the time, the HSI agents involved had statutory authority to conduct this investigation, and the defendant does not suggest, nor do the facts support, that the acting secretary McGallen or Wolf took any action that affected this investigation. See, this was my point. I was saying, like, do you really think some douchebag in Washington, and that I'm just going to say douchebag because I swear to God, politicians are all douchebags. I mean, whatever side of the aisle you're on, they're all douchebags. And do you really think Wolf or McGallen or Leland or whatever his last name is were really part of this? All right. You're the one to do it, girl. Thank you, Becca. Let's do it. All right. Let's get this up. The defendant asserts that a threshold matter, this court must assess whether the appointments of I don't know how to say his last name. I'm going to say McA and Wolf were unconstitutional under the appointments clause. And they say the defendant frames this issue incorrectly. The defendant's assumption that any violation of the appointments clause is in regards to the DHS warrants dismissal of this case fails to appreciate the fact that this indictment was brought by a grand jury and signed by the Assistant United States Attorneys of the United States Attorney's Office for the Western District of Arkansas and a trial attorney of the Criminal Division of the Department of Justice. Remember how I told you it was a joint effort and it was all under the umbrella of who? The Department of Justice, who, by the way, the Department of Justice is suing the state of Texas. Everyone, yay! All right. As a result, a defect as asserted by the defendant in this appointment process is of the acting DHS sector, even if found, would not find validity in the defendant's indictment. A valid grand jury indictment as pending at present is a constitutional fixture in its own right. An indictment returned by a legally constituted, unbiased grand jury is enough to call for a trial of the charge of merits. It is well settled that the validity of an indictment is not affected by the character of the evidence considered, and an indictment that is valid on its face is not subject to challenge on the ground that the grand jury acted on the basis of inadequate or incompetent evidence. The defendant's current claim that the indictment should be dismissed amounts to, at best, a challenge to the competency of the evidence considered by the grand jury, which would not affect the validity of the indictment. Indeed, if anything, the defendant's erroneous claim that the investigating agents acted pursuant to invalid authority would point toward a motion to suppress the evidence their agents collected, not a motion to dismiss the indictment. The defendant, of course, has not sought suppression, nor could he prevail in this context on a motion asking the court to apply the exclusionary rule to suppress the evidence these agents collected. The exclusionary rule has always been a last resort, not a first impulse. And suppressing evidence collected by agents who reasonably and correctly, as explained in this response, believed they were pursuing a valid investigation would serve no purpose in deterring unlawful searches and seizures. More fundamental, the defendant has not brought forth any action by the grand jury that would warrant the extreme action of dismissal and fails to cite an authority regarding an appointment clause violation forming the grounds warranting dismissal of a criminal case in the appropriate remedy. Oh my God. Okay. The United States Supreme Court has stated that failures by the executive branch, including prosecutorial misconduct in front of the grand jury, provide a court no authority to dismiss the indictment, absent finding that the defendant was prejudiced by such misconduct. In the current conduct, that means the defendant needs to establish grave doubt that the alleged appointments clause violation did impact the grand jury's decision to indict him. To create the requisite doubt and move then a harmless error, it is imperative for the defendant to show some consequential, prejudicial link between the disputed placement of the acting DHS secretaries and the grand jury's probable cause determination. You know, and I think they got a bunch of... Let me see something. This is the declaration of Juliana Blackwell, Executive Secretary at Office of the Executive Secretary, U.S. Department of Homeland Security. I've worked in this office since February 2007. I am responsible for maintaining the official documents approved or signed by the Secretary of Deputy Secretary of Homeland Security. I also know when a Secretary of Homeland Security vacates the office and when a new Secretary of Homeland Security begins as a secretary. The document attached, Exhibit 1, is a true and correct copy of the DHS delegation number, revision, DHS orders of succession. Exhibit 2 is a true and correct copy of DHS delegation, blah, blah, blah. The document attached as Exhibit 3 is a true and correct copy of the DHS delegation revision, DHS orders of succession planning, is a true and correct copy of the memorandum title designation. The document attached as Exhibit 5. Okay, so this is like the succession of how they're placed. Order of delegation of authority by the secretary. DHS orders and succession orders. Look at how many people are below. Look at how many people are below him. He's all the way number 1. There's 18 other directors. So I told you the person in Washington nuclear detection, let's see, emergency management, general counsel, health affairs, immigration. Here, assistant secretary, 1, deputy director, 2, executive associate director, executive. So do you see the deputy director on there anywhere? No. Got it. So basically, this person that they think is doing everything isn't even the person that's doing anything. Thank you. Okay. So The defendant creates the requisite doubt. Okay, the defendant has not provided a single concrete example of how the placement of the acting secretary has influenced or affected the grand jury's decision to return an indictment, meaning dismissal of the indictment is completely unwarranted. A review of the record reveals in this case the indictment is valid in all respects. The charges were brought by an acting United States attorney in Western state of Arkansas. The charges all support the cite federal law violations, which this court has jurisdiction over. And the indictment was brought by a grand jury sitting in the Western District of Arkansas. There are all facts that the defendant does not contest nor even address in his motion to dismiss. The motions fundamentally fails as dismissal is not valid remedy regardless of the defendant's legal claims. And it says that even if it was improper, it wouldn't deny them the rights. It would not invalidate the actions taken by the investigation. The defendant has not asserted that the acting secretary, Wolfer McA, took any official action related to this investigation. Could you imagine for a moment if the two guys in Washington were like, hey, Faulkner, you gotta get Josh Duggar. You know, I hate Jim Bob Duggar. We need to get his son set up. You need to take Jim Bob Duggar's son down. You know, even though he totally supports Trump and we love Trump so much, you gotta go after Jim Bob Duggar's kid. What kind of arrogance is going on in your brain that you think that these acting secretaries have any involvement in your case? It says the special agents, like all other federal agents under this umbrella, derive their authority from federal law. The Homeland Security Act of 2002 transferred the Secretary of Homeland Security all the functional personnel, assets, and customs service to statutory authority. And so they say that the delegation of authority to the Assistant Secretary for U.S. Customs and Immigration Enforcement. The delegation also authorized the secretary to redelegate the authority to an appropriate subordinate official to the ICE enforcement. ICE then internally delegated this authority to the Office of Investigators. So it's ICE that delegates the orders, not them. Told you. HSI agents have broad authority to educate, execute, serve, and order warrants, subpoenas, summons. They can make arrests for any offense against the United States, perform any law enforcement duty. The Congress has specifically tasked HSI with investigating cyber crimes against children. HSI agents are delegated broad authority to enforce federal law well before the 10 years of these acting secretaries, and agents' investigate authority is not contingent on the position of the Department of Homeland Security's secretary. This is awesome. Right here. Whoops. This part. Again, the defendant does not and cannot point to any authority supporting his sweeping claim that the improper designation of the acting secretary could deprive all 7,100 agents of lawful authority to investigate crimes. In fact, the cases that he cites all involved official actions taken by the officials who alleged to be improperly designated. Oh my God. This is what I told you. Imagine undoing 7,100 investigators' work. Right? It's unbelievable. Courts have unanimously rejected the view that the allegedly invalid designation of the acting Attorney General in 2018 invalidated all criminal prosecutions brought by the Department of Justice during his tenure, somehow affected his proceeding and prejudiced him in some way. They say that the same reasoning should apply here. Any violation of the order of succession of the Secretary of Homeland Security would not deprive agents of their existing authority to investigate violations of the federal law. It would basically be saying like the police chief was put on this place incorrectly, but every police officer has zero right to do any investigation. This is the best summation of the last 2.5 hours of my life. Every Duggar's arguments are based on arrogance and narcissism. It's true. So I don't want to go into this whole thing because it's really extensive. And I honestly don't think there's anything there because I don't think it's going to be a factor. So I think that argument is stupid. So let's sum this all up. Josh Duggar threw a bunch of shit at the wall. And as he threw that stuff at the wall, he is now pissed off the prosecuting attorneys. He's made the HSI people mad. And I feel like the judge is actually irritated because the judge already ordered a hearing for all of this. And I feel like independently, each one of them could have had their own hearing. And I feel like even the judge, by making the ruling for one hearing, tells me that the judge is like, shut up. That's just my opinion, but I feel like they threw so much at the court, and I feel like they've pissed off the prosecutors, they've pissed off the attorneys, they've pissed off the HSI. Like, the last thing you want to do is like piss off the judge, and this is going to piss the judge off. So that's my opinion. I want to thank all of you guys who hung with me for the last 2.5 hours. It was a doozy. There's probably more documents that I need to go through. So I do promise that at some point, if I find more information to share with you, whether it be in some of these affidavits, as I have more time to pull through all of this, I will bring that to you as promised. You guys are the reason why I do what I do. I could not have my success on this channel without you. For all of you that became members tonight, thank you so much. 20 of you joined. Artsy, so much to research. Thank you. You are so welcome. To every single one of you that gave a super chat tonight, I tried to thank each and every one of you. If I missed you, I am so sorry. My mods tried to thank all of you. Becca, read mine. I did read you. I read you a lot today. Rebecca had a lot of really good points. Thank you for keeping us up to date. You're welcome. So you guys, we did a Friday night, just like casual with my husband, and a lot of you guys had asked for another one like that. So I'm going to try to bring my husband back on for like a live stream, whether it's tomorrow night or Sunday night, just to have like a casual stream where we just like chit chat and hang out. But if you haven't subscribed yet, please subscribe. If you haven't given this video a like, please hit the thumbs up. And my husband is so nice. Thank you. Oh, Ebony, we love you. You know, off the cuff, I've had a really difficult few weeks, and I've been dealing with a lot of just hater stuff. And I love when I'm live and I'm with you guys, because you guys are the reason why I'm here. And I'm reminded so much about, it doesn't matter what the haters say. It doesn't matter what the people that don't like me say. This channel is why we're here. This little like island that we have on YouTube is our space where we talk about the fundamentalists. We talk about the cults. We cheer the Duggars that break the rules. We do all of these things. And, you know, it's hard because when I go on to Twitter, nobody that is on here is on Twitter. So if you're not following me on Twitter, and if I've blocked you, I apologize, but it's at WOACB official or Katie Joy WOACB. If you're not following me on Instagram, you guys, make sure you follow me on Instagram. It's at Without a Crystal Ball. I think we do understand each other. We have an amazing group of people here. To all of my subscribers that are survivors of the ATI or the Institute in Basic Life Principles, thank you guys. We see you. We appreciate that you're here. We appreciate that you send me information. Our hearts are with you. We know that it's hard coming out of this cult. You do have a place here where people understand you. There's lots of survivors from a lot of different cults that are in this community. There's a lot of ex-fundies in this community. So I hope that we can continue to keep fighting the fundies. Yes, we're going to keep fighting the fundies. Fight the fundies. And if anyone asks why we still talk about the Duggars, it's because of this. It's because of all of this contributes and is such a deep part of this fundamentalism. They hide this. Oh, Kim says, I'm a survivor. Welcome, Kim. We're so glad you're here. If you are a survivor of the IBLP and the ATI, welcome. We love you. There's so many of you here. I appreciate all of you being here. You have a space here, and we totally are empathetic to everything that you've gone through. We know it's not an easy journey. Fight the fundies. Yes, that should be a hashtag. I truly feel like you're bringing comfort and healing to survivors from all aspects, and in return, we can keep your spirit up. No one would be there if it wasn't for you. Well, thank you. I want all survivors. Oh, Muggy says she's an IBLP survivor. I see you. I'm sorry that you went through this. Esther says she's another survivor. I see you. I'm sorry that you went through this. I know it's a journey. I know you guys have a lot of healing and a lot of trauma, and we support you. We support your journey. We support all of it. We may not agree with some of your worldviews because of where you came from. We might have different opinions on politics, but that doesn't negate the compassion and the empathy that we feel. We don't have to have the same political views. Some people get really upset with me because I'm pro-choice and I'm pro-LGBTQ+. You guys don't have to agree with me to still be comfortable here. But I'm still going to speak out against that kind of stuff. So I don't understand why people have to be so ugly to one another. I don't either. We watch for Frida. Well, there she is. She's hiding behind the pillow. Oh, did you guys see that I have new merch? Oh, let me show you. Let's show y'all. We have brand new merch. Check out the Team Frida merchandise that's in our... Check that out. We've got Team Frida merch. And we have Ladies for Katie as well. That is also available. So we have Ladies for Katie and we have Team Frida merch. Make sure that you check out the new merch available in our Teespring store. Thank you, Cindy, for your super chat. Thank you guys all for your fun tonight. Thank you for survivors for being here. Thank you for non-survivors. Thank you for everyone coexisting. You already ordered your Rita, Tumblr. Yes, we have tumblers. We have, we've got tumblers for the ladies for Katie, which is pretty cool. There's even like masks, I think. Did I do masks? And as always, oh, and for all of you survivors, we have joyfully unavailable shirts. To a reminder that you can consent. You can say no if you're married. You do not have to give it up to your husband just because he wants it. And you have a right to say no. All right, you guys, thank you so much for being here. I love you. Make sure before you go, you give this video a thumbs up. And if you haven't yet subscribed, do so on the way out. Bye, guys.